Hi, my name is Carolyn Cromings, and I've been a licensed attorney in Texas for the last 16 years. And the majority of my practice has been in the construction industry. Specifically, I've worked a lot of time negotiating subcontracts, over thousands and thousands of subcontracts. I also have extensive experience in the courtroom litigating these construction contracts. And after all of my experiences, I wrote a book called Quit Getting Screwed, to help people who have to sign these contracts to not get screwed by the provisions that are in them. And so based on that, I've also started the Subcontractor Institute, which dives in deep and has suggested forms and suggested language on how to better negotiate the construction contract. So today, one of the dangerous provisions I want to talk about is the prime contract. Now, the prime contract by itself isn't a dangerous thing. The prime contract is an agreement, the main agreement between the owner and the general contractor for the entire project. That by itself doesn't harm a subcontractor. But what happens is in the first 2 or 3 pages of a subcontract document, there will be a list of what's considered the contract documents. And in that list, almost all of the time, is the prime contract. So what does that mean to you, the subcontractor? That means you're going to be held not only to the terms of the subcontract that you sign, but also to the terms of the prime contract, which seems like, how can that be? I've never even seen it, which is true. So, which is why one of the first things you need to do when you see that you're going to be held liable to the terms of the prime contract is ask for a copy of that prime contract. Because normally, you don't even ask for it, you just agree to the terms of it. And what happens later on, for example, I had one client that, signed a subcontract, the prime contract was in there. Their particular subcontract did not call for delay damages, but the prime contract did. And so when they didn't complete on time that they promised in their schedule, they were punished $1,000 a day because those delay damages were in the prime contract. So if the prime contract is incorporating your subcontract, get a copy. That's the first step. I would always try to have that provision taken out, because what it is actually is just a catch-all. If there's something they want you to be responsible for, it should be in your contract. You shouldn't have to go to some other contract to find it. But if you can, at the very least, get a copy of it so you know what you're agreeing to. In the book and at Subcontractor Institute, there's some form documents you can get to request that, or request that it being taken out, some language to give you to negotiate those provisions. But if you do agree to the prime contract being in the subcontract, get a copy of it. And the second thing I would try to do is get the same rights that the contractor has under that prime contract. Now, what does that mean? As a contractor, if the owner doesn't pay the contractor, the contractor can sue the owner directly. So if something like that happened and you agreed to the terms of the prime, but get the benefit of what the contractor had, then if you didn't get paid, you could sue the owner directly as well. So that way, if you are held liable or responsible to the prime contract, you won't just have the liability of it, you'll also get the benefits. So some exact language is in the book and at Subcontractor Institute. But so the prime is the agreement between the owner and the general. Most times it's incorporated into your subcontract. So 2 things, make sure you get a copy of it. And second thing, make sure or try to negotiate language that gives you the benefit of that contract, which can be found in the book or subcontractorinstitute.com. So we're here to help at subcontractorinstitute.com or the Cromings Law Firm. Thanks, guys. Have a great day.